State of Florida is now in session. The Honorable J.P. Cohen, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, good morning, everyone. Welcome to an oral argument session. I've been introduced. To my right, we've got Judge Orfinger, Rick Orfinger, from here in Volusia County. And we're honored to have with us today as an associate judge, Keith White from Orange County, who will be sitting with us for this today's session. We've got 3 cases on the docket. There will be 20 minutes given to each side. If you'd like more than a 5-minute rebuttal period, let me know that. I'll be glad to accommodate anything that you'd like in terms of rebuttal, but my default is typically 5 minutes. If you have any electronic devices, if you'd please place them on silent so that they don't interfere with the lawyer's arguments. Additionally, after the second case, we will take a brief recess and meet with the lawyers who wish for coffee in what used to be our library. So, the first case that we'll handle this morning is Watkins versus State, if you're ready to proceed.
May it please the court, opposing counsel. My name is Sean Gravel. I represent Mr. Watkins, and I will use the 5 minutes for rebuttal. And the main issue I'd like to focus on today is the first issue in my brief, which is the double jeopardy argument. What we have right here is an inter-county kidnapping, a single kidnapping which, according to the state prosecutors, started when Mr. Watkins confined the victim in James Ormond Park in Volusia County. He transported her to several different places.
What were the allegations in the information as to kidnapping?
The allegations in the information were that he unlawfully confined, abducted, imprisoned her for the purpose to commit or facilitate sexual battery, and he transported her to several places, but she was continuously his captive. At no point did he let her go, and she was his captive up until he choked her in the field in Flagler County and left her body, or her unconscious body, in the woods. She was continuously the captive. Each movement is not a separate kidnapping. She is continuously his captive, and because she is continuously his captive, that is a single kidnapping. And as a single kidnapping, he could not be convicted in 2 or more counties. Once he was convicted in Volusia County, the Flagler prosecutor should have null-prossed that kidnapping charge, and that is why we are asking this court to overturn his Flagler County conviction and sentence for kidnapping, because that is double jeopardy with the Volusia County kidnapping charge. And if I may touch briefly on the other 2 points on appeal. My second point on appeal was the motion to interview the juror and later the motion for new trial. As this court's case in Chung indicated, when there's a noticeable hesitation in the jurors.
But did the trial judge find a noticeable hesitation?
Well, the judge did notice it, but the judge did it, in the judge's finding, it was for a brief moment. But it was noticeable enough that, as defense counsel argued, should have warranted at least a questioning of why did you hesitate. And for the third point on appeal, as I argued in the briefs, I do believe that the Florida Supreme Court's decision in Pontaggio was wrongly decided, that the allegations that the victim made against another individual should have been admitted for the purposes of impeachment. I acknowledge this court.
So yeah, you want us to tell the Supreme Court that they were wrong?
Well, I would like you to ask the Florida Supreme Court to reconsider. Obviously, this court has no authority to overturn the Florida Supreme Court, just to certify the question, citing the federal case law. I cited saying, do you still believe your decision is right in light of these other factors? And that's all I can ask on that front, obviously. And
let me ask you about the first issue. What's your best case that supports your argument that the fact that there's clearly a kidnapping in Volusia and a sex battery in Volusia, and then there's movement to Flagler County and a second sex battery or sex act there? The state argues, well, the fact that there's a temporal break in the action makes it two different kidnappings. What's your best case that would dispute that contention?
The best case, I think, would actually, well, I believe it's a combination of both the Ashman case I said, but also the Vasquez case from this court, which dealt with a resisting arrest charge. And in that case, this court found that two of the resisting arrest charges were all one continuous act. There was no temporal break. It was a continuous act of arrest. That's the same thing in the Williams case as well. It was a continuous resistance. I believe it is irrelevant that there were ultimately multiple sexual batteries, because kidnapping, the very nature of kidnapping, is separate than the nature of a sexual battery. A kidnapping charge starts when the victim is unlawfully imprisoned, abducted, confined. It ends when the abduction, confinement, imprisonment ends. And at this point, the abduction, confinement did not end until her body was left in the woods. A sexual battery, by contrast, is committed when there's a penetration or union of two body parts, and it starts when the penetration or union starts, ends when the penetration or union ends. So that's why we're not contesting his sexual battery charges as double jeopardy, because the state's evidence indicates that there were clearly multiple penetrations, thus multiple charges, but the kidnapping was all a continuous kidnapping.
Was the Vasquez case, I'm a little hazy on the facts of that case, but was that a case where he resists an arrest with multiple officers involved?
See, I believe there were, multiple officers, but the charge was not battery on officer, it was resisting an officer, and in that case, as I recall the facts, they tried charging two resistances when they first arrested him because he, I believe, tried pulling away, and then they charged him with another resisting officer when he wasn't cooperating at the booking. This court found that the two resistances that happened simultaneously with his arrest was really a single continuous act of resistance, thus had to be a single resisting charge, whereas the failure to cooperate at booking was a separate resisting charge. But in this case, it is all one continuous kidnapping. He confines her in Volusia County. He doesn't let her go. At one point, he might have considered letting her go, as the state indicated, but before he actually let her go, he changed his mind and decided to continue confining her. So she is continuously his captive through this whole ordeal. As I noted in my brief, the only arguable temporal break is when he left her in the field. She wakes up, starts walking away, he sees her and grabs her again, but that is kidnapping with intent to commit attempted murder, which was an uncharged crime, which does not defeat his double jeopardy claim, since the charged offense in both counties was kidnapping to commit sexual battery. He kidnapped her, committed sexual battery multiple times, but it was all one continuous kidnapping, starting in James Ormond Park and continuing until he eventually leaves her unconscious body in the field in the woods in Flagler County.
Well, what's your response to the state's argument that when you mentioned that the defendant had made a promise to take her back and changed his mind and then took her into Flagler County, that is a separate, successive criminal impulse that can be dealt with, treated as a separate offense of kidnapping?
My counter to that is the fact that even though he may have intended to let her go, he did not actually let her go. She was still his captive. He was essentially saying, okay, I'm going to let you go. Then he changed his mind and decides, no, I'm going to continue holding you. So he was continuously confining her. This would only have been a separate charge if he had actually said, okay, you're free to go. She starts walking away, and then he says, I changed my mind, I'm going to kidnap you or continue confining you. But and that would have been a temporal break if he had actually let her go. But he did not actually let her go. He continued confining her. She was still in his car. She was still under the threat of, if you try anything, I'm going to shoot you with this gun I claim I have. But it's all one continuous kidnapping, thus should only be a single kidnapping charge. And if your honors have no other questions, I will rest on my briefs. Thank you, Your Honor.
Thank you.
Good morning. May it please the court, counsel. Andrea Totten on behalf of the state of Florida. Your Honors, with regard to the double jeopardy claim in issue 1, the question here is really whether the defendant had time to pause, reflect, and form a new criminal intent between
The nature of kidnapping is it's the restriction, and when did that stop?
Your Honor, my response to that would be it stopped at Highbridge Road in Ormond Beach initially at the time when the defendant said to the victim, "You've done a good job. If you do these things, I'm going to take you back to town now, to Daytona Beach."
Did the confinement ever stop?
I would argue at that point that it did, Your Honor, because the testimony from the victim indicates at that point she is under the belief and impression, based on his promise, that he's now going to take her to Daytona.
You can promise anything. Did the confinement ever stop?
She got back into the car, based on her testimony, of her own volition at that point because she thought that he was bringing her home, that the kidnapping had come to an end. That was her belief based on her testimony at trial and based on his statements made to her. She wasn't forced back into the car at Highbridge Road. She testified that he let her get dressed, she got back into the car, into the front passenger seat, not in the back seat or the trunk or anything like that, and at that point, they were going to go back to Daytona Beach. That was based on his statements and her statements. At that point, he had no further criminal intent to kidnap her or to commit any other crimes against her, it seems.
Well, her belief doesn't impact his intent.
I
You seem to think that because she got back into the car voluntarily under her belief that he was going to drive her back to Daytona doesn't impact his intent, and does it? I mean, how does her belief affect his intent?
Your Honor, I would agree with you, but I think that his own statements, as testified to by the victim, demonstrate his intent. He said, "I'm taking you back to Daytona now," and they're driving in that direction.
You know what Spiro Agnew said about that?
I'm sorry, Your Honor?
You know what Spiro Agnew said about that?
I don't, but I'm waiting to find out.
Spiro Agnew.
Me too, Your Honor.
Said, "Watch what we do, not what we say."
I don't disagree, Your Honor. As the victim testified, he started to drive back towards Daytona Beach, making good on that promise, and everything is going just fine until he's trying to find his cell phone. She says, "Let me help you," reaches behind her, finds his cell phone on the seat, and says, "Here, I found your cell phone for you." At that point, and I would point you to the trial testimony on this from pages 357 to about 359 in the trial record. At that point, there's a clear change in his mindset. He does a complete 180. "What are you doing? You were trying to call someone with my phone, weren't you? That's it. Plans changed. Now you have to die." And it's at that point that he goes to Flagler County.
Your theory then is that the kidnapping ends at the moment that he starts to drive her back to Orlando, or back to, not Orlando, but Daytona.
For the purposes of this double jeopardy argument, yes, Your Honor, because again, the relevant question is whether he had time to pause, reflect, and form a new criminal intent.
So under that theory, if a kidnapping occurs for a period of 20 days, and forget the fact that they got moved around or anything else, the person gets snatched off the street and put in a locker for 20 days. I mean, certainly in 20 days, you would concede that that the kidnapper would have time to pause, reflect, and form a new intent. I mean, your argument would seem to suggest that, you know, if you've got a 20-day-long kidnapping because you have this ability to pause, reflect, and form a new intent, that you've got, I don't know how many different kidnappings, but you got a bunch of them in that period of time.
Well, I would agree with you that it's very fact-specific, Your Honor, but the facts in this case...
But let's come back to my hypothetical. I mean, if a person's kidnapped, they're not moved, they're not sexually battered, they're just restrained for 20 days.
Okay.
You would concede that the kidnapper would have adequate time to pause, reflect, and form new intents during that period, wouldn't you?
Yes, I would agree that he would.
So is that one kidnapping, or is that 20 kidnappings, or a gazillion? I mean, what is it?
Well, I think it would depend on the facts. If you had facts indicating,
Well,
like you have
I just gave you
here...
the facts.
I'm sorry?
I said, I just gave you the facts. That's
Well,
why it's a hypothetical.
if we have no additional facts indicating his intent whatsoever, then possibly not. But I would argue that's simply not what we have here. We have a clear temporal break at High Bridge
And
Road.
and the temporal break is, I'm going to let you go sometime in the future?
Well, with all due respect, Your Honor, I would disagree that it's at some point in the future. I'm driving you back to town, which is only from there a 15-minute drive or something, right now. That's what we are doing. And then he completely changes his mind when he becomes enraged, thinking that she's trying to call someone. I'd like to draw your attention to Capron v. State, which is a decision from this court from 2007, to quote, "In the period that it took Mr. Capron to take M.W., the victim, to the sink and wash her and then walk her back to the bed," and this was a sexual battery, lewd and lascivious type case, "he had time to pause, reflect, and form a new criminal intent." They're in a hotel room.
That fact, I think I wrote that case, if I remember correctly.
I think you may have, Your Honor.
I think those facts are completely different. That's a sex battery, lewd and lascivious case. And the Supreme Court has held, most recently, I think, in the Meschel case, that each sex battery is a separate crime. I mean, this seems to be a different nature of the beast as far as, I mean, I understand what that case said, but I think factually it's significantly different.
I agree that
He commits a sex battery, there's a break in the action, they go to the bathroom, do whatever they do in the bathroom, then they come back and he commits a second sex battery or a lewd assault or some other separate act. And it seems to me that those are discrete acts on different parts of the body, as I recall in that case.
there were discrete acts, although this court did find double jeopardy as to two of the counts. But with regards to that, the defendant did argue double jeopardy. It's a double jeopardy case. I think there was other issues raised, but that was certainly one of them.
We didn't buy it because we said that the sex batteries are discrete crimes that you can commit in a number of different ways. I mean, that's not true with kidnapping. Kidnapping isn't something that you can commit in different ways. And
Well-
there's no time limit. I mean, I could kidnap you for 10 minutes or 10 days or 10 years. And, I mean, I might commit other crimes along the way, but it seems to me that, you know, there's got to be some bookends to it. What difference does it make, if any, in this case, that he took her to Flagler County? I mean, I know where James Ormond Park is because I live right up there. I mean, if he had driven her from James Ormond Park to DeLand in Volusia County, would that have made a difference? You think the fact that they go to Flagler County has any impact on it? I mean, Flagler County from James Ormond Park's about 100 yards.
Right. No, except that that's another indication of a break in time, location,
So even though he drives
temporal.
30 miles to DeLand from James Ormond Park, but he drives 100 yards from James Ormond Park to Flagler County, that's a factor that we ought to consider that weighs in favor of the state?
I would argue that it would be a second kidnapping if he drove her from DeLand from High Bridge Park based on the facts of this specific case. So no, I'm not saying that it's decisive that he drove to Flagler. That's just indicative of his change of mindset. I'm bringing you back to Daytona Beach
But the
Now I'm
gravamen- the
enraged, I'm changing
gravamen
my
of-
mind.
The gravamen of kidnapping is the confinement. And I'm struggling to accept your analysis in terms of she was no longer confined. I mean, I don't see any break in the confinement of this victim.
There's no question that she was at all times in his company. She was in the car with him at the time that he changed his mind. But again, I think that that's what's relevant here. It's the time to pause, reflect, and the formation of a new criminal intent. He formed a new criminal intent when he went from, I am returning you home to Daytona Beach, this is over, to, I think you're trying to call someone with my phone, now I'm enraged, I'm changing my mind, I'm forming a new intent to take you to another location to rape and kill you.
So
That's where the break
under
is.
Judge Orfinger's hypothetical, where you have a victim that is confined for a number of days, if the kidnapper says to the victim, I'm going to let you go, and then doesn't do it, and tells her that every day, are those different kidnappings because he said, I'm going to let you go?
Perhaps not just with that fact, but here we have the additional fact supporting what he said. He's driving back to Daytona Beach, and there's something that happens, the becoming enraged, thinking that the victim is trying to make a phone call on his cell phone, that also support that. So we're not stuck with the bare statement from the defendant saying, I'm going to do this. We have other supporting facts. And I think that that distinguishes our case from your hypothetical, Your Honor. Your Honors,
How do you distinguish Ashman?
in that case, the defendant kidnapped the victim from her home in Orange County, and the facts indicate drove directly to Polk County with no stops, where he raped her and attempted to kill her. He was charged in both Polk County and then later in Orange County with kidnapping based on those exact same set of facts. So what's different is here we've got a 9-hour ordeal where there's multiple stops and rapes and the argument that I just made regarding the break in time. Here, there's simply no break. He goes directly from Polk County to Orange County. Your Honors noted in the Ashman opinion that the victim tried to escape at one point. Based on the order in which that sentence appears in the paragraph, it seems to me that that didn't occur until Polk County either, and it really wasn't part of the court's analysis. So it's simply factually distinct because it was a direct line, and if the facts in the instant case were he picked her up in Volusia County, drove straight to that field in Flagler County with no stops and got her out and raped her there, then it would be exactly like Ashman, but that's simply not what we have here.
Would you have forget that there's a sex battery? I mean, if he snatched her off the street in Volusia County and drove her directly to Flagler County, where he, locked her in a room and kept her for a week, I mean, is that one kidnapping or is that multiple kidnappings? There's no other intervening crimes.
Well, I think that's similar to your earlier hypothetical where we have no facts other than the victim is in a room. So under those facts, that probably is just one kidnapping. But again, I would argue that that's simply not what we have here. Vasquez is similarly distinct. The defendant was charged with 2 resisting without counts at a restaurant where he was being disorderly. Then he's transported to the police station. He again becomes resistant, and there he's charged with 1 count of resisting with violence. The court found that he couldn't be convicted of the 2 resisting without charges that happened at the Steak and Shake restaurant because that was one brief continuous event at that same place with those same officers. But the court had no issue with him being convicted for resisting at the restaurant and then a little while later again at the police station because the court said that there was a temporal break, a break in time, location, and intent.
At no time did he let this victim go. You agree with that?
Well, you know, the facts are that she got back in the car on her own volition at High Bridge Road. So there was not testimony that he said, go run free. But I would argue that at that point, his indication was that he was letting her go. He was going to give her a ride back to town because they're in such a remote location. That's what he said. That's what she believed. At that point, I think that she's in the car on her own volition based on his promise, I'm giving you a ride back to town. At that point, there is no kidnapping happening. The event is over. I believe that the testimony supports that. He believed that it was over, and she believed it was over, and that things only changed once it came to her trying to help him find his cell phone. So I would argue that there was a point in time when that first kidnapping distinctly ends and then begins again based on the facts of this case.
Right.
If your honors have no further questions, I will rely on
I
my...
have one question. What's the state's response to the defense argument that in the Volusia County case, the state treated this as one offense?
Your Honor, are you referring to the argument that the state argued to have the evidence from both cases, the inextricably intertwined argument? Because the state did argue...
I think that's part of it.
Yes.
But also the totality of the record in the case on appeal currently from the Volusia County verdict is, if I'm understanding the defense argument, the way I understand it is the state treated that as one offense, and so therefore under the statute, a conviction on one offense precludes, if it could have been brought in two counties, precludes a subsequent conviction.
Well, Your Honor, I'm not sure that I would agree respectfully that the state treated it as one event for the purposes of the crimes being charged. The state did argue in the trial court, both in Volusia County and in Flagler County, that all of the evidence, starting from that first encounter in Volusia County to the last in Flagler County, was inextricably intertwined and therefore admissible to paint a picture for the jury of the entire set of circumstances. But and I pulled portions of it and attached it to my appendix in my answer brief. The prosecutor in Volusia focused on the events at James Ormond Park, going to High Bridge. Obviously, there was argument and testimony that came in concerning the further events from there, but I would argue that the state's argument regarding the continuousness of the events really had to do with the admissibility of evidence, and is just a separate issue from the double jeopardy issue.
All right.
Thank you, Your Honors.
Please the court, opposing counsel. The only comment I have in rebuttal with regards to whether she voluntarily entered the state's evidence was that at one point he had threatened to shoot her, and a victim under fear of death isn't really acting willingly. Thus, I agree with Your Honors that this does appear to be one continuous act. And if there are no other...
All right, the state suggests that the victim got back into the car voluntarily.
I do not recall the state making that suggestion at the trial level. The first time that suggestion even occurred to me was just now in oral argument hearing Ms. Totten's argument. But I maintain that this was one continuous kidnapping, started at the James Ormond Park in Volusia, continued till he leaves her unconscious body in the field in Flagler County.
All right, so do you think the evidence supports the state's argument?
The state's trial argument that this was all one continuous kidnapping?
The state's argument, oral argument.
Oh, at oral argument, I'm sorry, Your Honor. The state's, no, I do not, Your Honor. I believe that this is, as Your Honors were suggesting in your hypotheticals, a single continuous kidnapping.
So, counsel, are you saying that under the evidence presented at the trial court in this case, it would be impermissible for the jury in weighing the evidence to conclude that, in fact, what your client said was true, and he was releasing her, and he was, for a moment, going to take her back to Volusia County? A brief moment, contemplated it, then changed his mind. Could the jury reach that conclusion? Are they permitted to do that?
Well, the jury could, but the jury did not reach that conclusion. Obviously, the jury disbelieved Mr. Watkins' defense, which was during the whole trial, he tried claiming this was a consensual encounter. She's falsely accusing him because he refused to pay her. That was his defense. The jury obviously rejected that. They found the victim, much more credible. And if there are no other questions, I will rest on my arguments.
All right, thank you.
Your Honors.
Thank you both.